Yes, welcome to the No State Project for March 11th, 2017, live from the fortified compound in Mesa, Arizona. Glad to be back with you here live. We missed the Wednesday episode for tech issues, and because I'm traveling, we're not going to have a live Wednesday broadcast this upcoming week, but we'll have new material. You want to join me here on the big show, you may do so at 218-632. You think I would know that by now. 632-9399. That's 218-632-9399. And on Skype, it is Frank Rizzo 3. That is Frank Rizzo with the number 3. And send me an instant message before. Don't just call during a live broadcast. I will bring you up on a break. We like to bring everybody up in order of the call. Unless, of course, they let me know ahead of time that they are a critic, and we like to get them up. We like to give them priority, if you will, there. So, I wanted to discuss a bit today about a very... It just keeps rearing its head, regardless of the circles in which the material is presented. And look, I'm not really big into somebody's social, what do you call it, social media. I understand I got material that although there's a mountain of evidence to show how true it is and how people have replicated the results on 3 damn continents, I understand it's kind of a tough sell. People really cling to their conditioned thoughts and what they think is actually a thought process instead of just a mental habit. The idea that even an anarchist or professed anarchist, it was kind of, it's just something I wasn't used to seeing, and I'm getting used to seeing it now because it's obvious that just because someone calls himself an anarchist or an anarcho-capitalist or a libertarian, there's still a major mental block when it comes to the fact that there is no state, there are no citizens, there is no government, they're just men and women forcing us to pay them. And that their rules, their special rules, there's no evidence they apply to anybody. The latest video, and I thank everyone for sharing that, it's actually doing fairly well. And what it has to do, it's called the dirty prosecution tactic, flipping the burden of proof. And so I posted on Steemit, and that's the thing. I rarely go. I do it just to, I don't know, I still post on Reddit. It's usually a cesspool over there. It's very rare to encounter anybody who has an open mind and it doesn't piss all over you, and downvote you so no one gets to see your post. This isn't happening necessarily. It has happened on Steemit, but this particular one, no. But I've got somebody on here saying that I'm preaching nonsense and that he downvoted for quackery. And the proof beyond a reasonable doubt standard applies to issues of fact, not issues of law. Issues of law in countries that use the English common law system, Canada, the US among them, are decided based on stare decisis, the judge's interpretation of prior court rulings. It's a bug, not a feature. This is going to keep coming up, and we need, people who are new to it need to know how to defend against this crap, whether you're in or out of court. Clearing out all the public relations. The Constitution is literally 4 pieces of paper. It is a written instrument, and even the U.S. Supreme Court and other Supreme Courts agree with that basic fact. The Constitution, and even George Bush agreed, it's just a damn piece of paper. That's what it is. So the idea that it applies to somebody and creates obligations on them, and that you think that is just a theoretical issue of law. No! I don't know how many times you got to explain this, but I guess it's new people coming in and the show is still growing and growing, and we're going to keep getting the same stupid, tired, logical fallacies. This is conflating. Stare decisis is for theoretical issues of law, okay? Not practical application of the law. Once you apply it to somebody, you need evidence. I mean, even the Supreme Court, This is Ex parte Burford 3 Cranch, page 448. The standard, and it's being quoted in a more recent case, of course, Gerstein, it's 420 U.S. 103. The standard for arrest is probable cause, defined in terms of facts and circumstances, sufficient to warrant a prudent man in believing that the suspect had committed or was committing an offense. Well, does the Constitution and Code apply for there to be a violation? It's this insistence. You can have a written instrument, something on paper. If you're claiming it applies to somebody and creates obligations on them, that's not a practical, a theoretical issue of law. That's not something you go and see what the courts have ruled on. No. Whether something is a contract that applies to somebody and creates obligations on them, and I'm not saying the Constitution is a contract, doesn't even purport to be, it's just 4 pieces of paper. But whether a written instrument does apply to somebody and does create obligations on them is usually a trial issue. You only look at business litigation. There's a reason why it takes so long, because people will doubt that there's actually a contract there. It's not a matter of, oh, let's just see if the judge says it's a contract and whether you agree and whether you comply with it. You have to first show that it is a contract, that it does apply. And you don't do that with stare decisis. What they're doing here is conflating stare decisis with res judicata. Res judicata is the thing has been decided. And that's where I get part of the subtitle of Adventures in Legal Land, where black is white and white is black. Because once there has been a proper, fair determination on the merits, and it only applies to that specific case. Res judicata means it's been decided. So once they've had a trial and it's been proven to be fair, and there was due process and there was a cross-examination and all this stuff, these particular sets of facts cannot be revisited. It's been done, and that's why black is white and white is black. Once they've decided it and you've had an opportunity to defend, then it's been decided. But that is not how stare decisis works. Every case is fact-specific. Stare decisis is for answering legal questions such as, is prosecutorial misconduct arguing without evidence? That's a pure theoretical issue of law. Now, did Bill Burke commit prosecutorial misconduct? That's a practical application. I can't just turn around and use the definition. Stare decisis. Arguing without evidence is misconduct. How do you know I did that? Where's your proof? It's going to come up. It's going to come up. It's going to continue coming up where people are going to say that the application of a written instrument from 1787 is an issue of law. And it's not. No other document has that, because what you have here is what they're saying is that the Constitution, even though it's 4 pieces of paper, they are trying to get you to accept a double standard. Oh, the Constitution is from Odin, and it doesn't follow the same basic principles of logic and reason. So while you could never bring the Constitution into court and have it determined to be a contract, because there's no factual basis to support that, they will still insist that it's an issue. Somebody needs to explain this double standard. If you are one of the type of people who thinks that whether the Constitution, the 4 pieces of paper from 1787 applies to me today just because I'm physically in North America, you need to bring a valid reason why you're applying a different standard. Why doesn't the standard for every other written instrument apply to these special ones? I'd love to hear it. My name is Marc Stevens. We're up against a break. We'll be back here on the No Say Project in just a moment, taking your calls at 218-632-9399 and Frank Rizzo 3 on Skype. Yes, we're back here live on the No State Project. My name is Marc Stevens, author of Government Indicted, which you can get at markstevens.net today. Also available as an ebook. Has a whole model for how to effectively defend against these bureaucratic attacks. And if you go to markstevens.net, you can see people, and you can and you get the success stories, and you also get to the show archives, people who have used the model effectively, which is really just based on principles of logic, that the burden of proof is always on the one making the accusation, and using the Socratic method to hold them to that burden. So a little bit more about this idea. It's amazing the mental gymnastics that people will go through, where they'll say it's theoretical or philosophical. See, it depends on who you're talking to. Everything that I'm doing is philosophical or theoretical, but when I'm questioning them on what they say is theoretical or philosophical, there's no logical consistency here. Zero. You would think people who are professed anarchists would at least watch the video, and instead of just calling it quackery or just making an argument that has got no basis in rational, no rational basis, to turn around and just say it's quackery. This is where I tell guys, you are not supposed to call during a live broadcast. If you want to go on Skype and you want to be on the show, please just instant message me on Skype, and then I will bring you up during a break. On the Wednesday show, it's a little different. We don't have any commercials, so we kind of have to do that during the show, but at least I have the option of muting because I know that I'm calling you. So please, if you want to join the show, I think that's great. I will bring you up on the next segment, or for the next segment. So please, I hope that didn't go out over the air. I don't want to turn it off right now in the middle of a broadcast. But hey, that's what happens during a live broadcast. It's better than a tech issue, which so far, hey, we're doing all right over there. So, again, this is just a dishonest tactic because not only do they turn around and say, like what we have in the call to shame. And remember, in the call to shame in the video I just posted, the attorney didn't try to make the argument, Mark, you're an idiot, you're a quack. There's no evidence. It's not an evidentiary issue. The Constitution applies because it's the Constitution. He didn't make a statement like that. Because when you're saying it's an operation of law, or you're saying it's an issue of law, what you are saying is this claim cannot be proven true. And like Hitchens, I'll keep saying it because it's so appropriate here. That which can be asserted without evidence can be dismissed without evidence. Now, that doesn't mean we're going to win a court, get a ticket thrown out. But what we're doing is we're showing how dishonest these people are. So they want to have it however they need to argue it in order to prevail, so that they don't have to admit the obvious. There has to be proof to be valid, but there isn't any. Why? Because they're just men and women forcing us to pay them. That's why. That's why you have to keep saying these things. Well, it's an operation of law. What the hell does that mean? Other than what I can get, like prosecutors have told me, Lon Seal up in New Hampshire, state attorney, the laws apply as a matter of law. Remember, we want to look at the facts and look at this rationally. We're not going to look at this in any kind of, matter of faith. They're just rules. Even their own court opinions, stare decisis that people think is so wonderful. All the Constitution and laws are written rules of people called legislators. That's it. So, another way of saying the laws apply as a matter of law is to say the rules apply as a matter of the rules. And you're missing the foundation. That's circular logic. But that doesn't apply in court. Yeah, but the prison system does. It applies because we are exposing them for the criminals that they are. Okay? And you should do that in and out of court. Isn't that circular logic? And I've actually said this. Can't I just say the rules don't apply because the rules don't apply? It violates natural law. And that's another double standard. They don't accept that from us, but we're supposed to accept it from them. And something that I realized today, this week, writing a motion for federal court. They want to turn around and say quackery. And the prosecutors love to say it's frivolous. Frivolous, frivolous, frivolous. Well, you know what? Arguing without evidence really is as close to a definition of frivolous as you can get. Arguing with a shred of evidence and using nothing but proof by assertion fallacies. It's the law. And without actually giving any proof of what that's supposed to be. And that's why we need certainty in our words, instead of conflating and equivocating the whole time. Words are supposed to mean something. Or are we using alternative facts? Oh, wait, that's right. They're not using facts. They're using alternative logic. Well, Mark, you can't make an appeal to tradition argument in court and have it stand up. Really? Why not? Why can't I point out that the only reason why this has any validity whatsoever is because someone in 1805 said it? Do the facts still bear that out? Is it still a rational statement today? There's a lot of things that happened in 1805 that is considered rational today. In 1805, brown people and black people of African descent were considered property. That was normal. Are we still going to use, well, you know, it's just the way it is. Fungal, it's just the way it is. We are working here on the No State Project to change the way it is. So we don't, it's not being accepted, these logical fallacies. If you don't have evidence and a logical basis and you're not willing to back off, you're a criminal. That's the way, you're just dishonest. Try to set it up by saying, well, it's an issue of law. No, it's not. No, it's not. I don't know how many times we're going to have to repeat that. And apparently, like I was talking to Calvin off air, we're going to have to do this a lot because, again, as this show keeps getting bigger, we're going to keep getting more and more of this and people are going to be encountering this more. Because there's no other way to avoid the obvious, which is they're just men and women forcing us to pay them. Why would we go based on their logic anyway? Why would we use their logic? For any other reason than to show that they're contradicting themselves and that they're crooks. So there's a common one. Why do you keep quoting the due process clause? You can't invoke the Constitution if it doesn't apply. Which one is it? You use the due process clause to show that their actions are not consistent with their rhetoric. The way they are acting as benevolent protectors of life, liberty, the fact that they think that they're protecting life, liberty, and property, while forcing you to pay them, we just bring up their own rhetoric, their own public relations to show that they are contradicting themselves. That's how we prove that they are crooks, so that hopefully, like I wrote in Adventures in Legal Land, they will leave the gun under all that paperwork and leave us alone. We make it too difficult for them to make it look good. That's why we do it. It's a tactic. Not because we think it applies. We'll be back here on the No State Project with your calls in just a moment, so don't go away.